Mate, this is your Lordship.
Yes.
Lordship, item 5. Lordship, kindly have this matter after 10 days, Your Lordship. Today I have some personal difficulties.
No objection. On the prayer made by Mr. Additional Learned AG, this is matter after 2 weeks.
2 weeks.
2 weeks will do, Your Lordship, yes. Apply, Your Lordship.
May I please, Your Lordship?
Yes.
I'd like to mention item number 9, Your Lordship. Bring for 2 weeks' time because the conducting counsel is having some personal difficulties, Your Lordship.
Criminal appeal.
No objection.
Mr.
D. Dakhar.
Learned counsel for the petitioner. Praise for grant of time. He's appellant. Learned counsel is the appellant, not petitioner. It's appeal, isn't it?
Yes.
Praise for grant of time. For 2 weeks. 2 weeks.
2 weeks, Your Honor.
Mr. Give your name, please.
J. Thaba, Lordship.
Applying for the respondent. Has no objection. No objection.
Objection.
Prayer allowed. List after 2 weeks.
Hello.
Intervention, Abhishek. You mentioned,
Yes, Mr. Shan, anything?
no, it's this item number 8 of the hearing list.
Yes.
This is joint prayer for an adjournment, my lord. So if Lordship's going to have it next week.
We'll have it after 2 weeks.
My lord.
We'll have it after 2 weeks.
Lordship.
On the joint prayer made by the parties, list this matter after 2 weeks. Item 8.
Ali oblige.
Your Lordship, I beg to mention item number 7.
Yes.
Your Lordship, I pray for 2 weeks' time, Your Lordship. The conducting counsel has some personal difficulty.
What is this? Is against conviction? Conviction by security force. Security force code.
Security.
Okay. This is also joint prayer, or the
No,
prayer of the
petition.
petitioner. Yes. On the prayer made by the learned counsel for the petitioner. List is matter after 2 weeks. Item
Highly
7.
obliged, Your Lordship.
Lordship, I beg to mention item number 6. The learned DSGI is out of station, Lordship.
Petitioner.
Petitioner,
Mr.
Your
Given. No objection.
No objection, Your Lordship.
Yes. Right. Miss A. Pradhan, appearing on behalf of the respondent, submits that Mr. Dr. N. Mojika, learned DSG, is out of station. Stop. She prays for an adjournment of the matter. Prayer has not been opposed by the learned counsel for the petitioner. List after 2 weeks.
Lordship.
Okay.
Lordship, I have a similar prayer for item number 2.
Item number 2.
Yes, Lordship.
Petitioner. Who is petitioner?
Sir Gautam is the petition.
Item number 2 in orders. You let it come up.
Your Lordship, I just beg to mention item number 10, Your Lordship. I have taken the concern of the other party.
And for the respondent, Your Lordship.
Item. Okay. On the prayer made by the learned counsel for the petitioner and not opposed by the learned counsel for the respondent, list this matter after 2 weeks.
Highly obliged.
Congratulations.
Supplementary list, item number 1.
Yes, Mr. Khan, what your instruction is?
Lordship, the instruction is that public prosecutor has not been appointed. Lordship.
So what is to be done? This has to be taken up.
Lordship, we just try. We just the instruction we received, but I'm sure, Lordship, there should be assistant public prosecutor. APP should
But
be.
then for how long the court function without
Very
prosecutor?
unfortunate. Absolutely, very unfortunate. There's nothing much I can say. In spite of the fact when we shot down the letter, the government should have. We requested them also, not only like whether PP is there or not, but appoint and let the trial proceed.
Now this petition requires to be disposed of by the court.
Absolutely correct. There's only specific.
The High Court cannot take over the thing and then
And
say
also-
it can only pass a direction saying that you take up the matter.
Lordship.
But then at this stage, before you come with something specific instruction, like you cannot just take a stand that prosecutor will not be appointed until
Well,
later.
it has not been. The instruction that we received is not that is not been appointed.
Please then you just communicate
Lordship will do one thing. One
to the
more attempt.
government, say this is things cannot remain pending like this.
Lordship is correct. Because the application has to be disposed of.
Yes.
Section 80 application before this, district section has to be disposed, which is pending and it can't be disposed of because of PP. Very unfortunate. Lordship will convey this and ask the law department at least to appoint.
You want a judicial order for that, or you'll convey and just you'll try by.
But sometimes, Lordship, judicial order works. Otherwise, our opinions hardly matters. It will remain only in the state of opinion. Otherwise, we'll do one thing, Lordship. Give us 1 week's time. We'll convey them.
Yes, madam. Wait for a week. Mr. Khan, learned AG, appearing with the respondents, submits that the petition in question could not be taken up by the learned trial court due to the fact that there is no prosecutor appointed by the state.
Public prosecutor.
There is no public prosecutor appointed by the state for the particular district. Come on, Mr. Khan, please, for grant of another week's time, so that he can pursue the matter with the state.
Lordship.
Period allowed. List this matter after 2 weeks. We'll give you 2 weeks.
Please, Lordship.
Please do it. It's a simple thing. Otherwise,
Absolutely
why should
correct,
we?
Lordship. They can do it within a day.
It's all right. Okay, I've listed it.
Item number 2.
Your Lordship, in this matter, we have just received the affidavit yesterday, Your Lordship. I pray that the matter may be fixed for hearing on the next day.
Okay. It is submitted that the respondent has filed their affidavit opposition in the matter. The learned counsel appearing for the parties we do not say submitted. We just say that the respondent have filed affidavit opposition in the matter. Stop. It is submitted by the parties. That matter is ready for hearing. List this matter after
2 weeks later.
2 weeks for hearing.
Highly obliged.
Highly obliged.
Item number 3.
Yes.
Wait, please.
Yes.
My lords, steps on respond number 3 had been taken on 24/8, my lords, and notice has been served on 4/9. We filed an affidavit to such effect, my lords, yesterday.
But this is not a certificate. We have not.
It's from the Postal Authority, madam. Page 6, madam, of the affidavit.
Yes, but that is only download copy. Normally, what happens, sir, like you ask for, they issue a certificate of service. That is what is required. What has been done normally in all the cases.
Well, but now this facility is available on online tracking. Well, that.
But then
Item delivered, my lord, to the addressee.
Normally in all cases,
your lordships are correct.
There is a certificate.
But earlier we would seek we would make a request to the postal authorities to issue us a certificate. Your lordships are absolutely correct, my lords. Earlier we would do this. But now it is available on real time, my lords.
Is this authentic? Is this can it be relied upon for holding that notice has been served?
My lords, in my humble submission, my lords, it should be, because even under the IT Act, my lords, this would be now recognized as valid service of notice.
Okay. The petitioner submits that an affidavit of service showing the service of notice upon respondent number 3 has been filed. None appears for the respondent number 3. After full stop, you write none appears for the respondent number 3. Matter is otherwise ready for hearing.
Otherwise ready for hearing.
Yes. The matter is
next week, my lord.
Next week. You are eager to do it. You are eager to do it.
No, I'll try to.
Mr. Shankapto seems to be more eager than you, Mr. Paul.
I'm grateful to my friend. We can try and close this matter, because I think my friend also would realize there's nothing much in that matter. Your lordships had seen, he's not even present on the day on which the occurrence happens. He's not named in the FIR, just a passing reference.
Let's just after this thing, none appears for one more thing. Then thereafter you say, the matter is ready for hearing. List this for hearing after 2 weeks.
Obliged.
Item number 4.
May it please your lordship. As
Yes.
per the last order, your lordship, steps have been taken, your lordship, and we have filed our affidavit in compliance.
But in this case, we are entering evidence. We have just entered evidence for 2
To entry. What is the matter about? This is?
Your lordship, it's regarding for quashing of FIR, your lordship, registered under section 44.
This is 482 application.
Yes, your lordship.
You are filing. You are going to file your objection.
No, this matter has been otherwise compromised between the parties. The compromise deed has been annexed to this petition.
Why this offence alleged is not compoundable?
I think except one. Others are all compoundable. On the section 3 of the Prevention of Damage of Public Property Act, that is, the punishment is 5 years. Otherwise, is all are compoundable. But so far, the issues are concerned, when it has been resolved.
Can it be? Can it be?
The question of law.
State? What is it? Can it be? Can it be compromised?
Lordship, Mr. Shulai is leading this matter. He's on leg, so I may be allowed to take instructions on this.
The instruction will not do. You have to basically show. We'll place it for hearing on some other day. If Mr. Shulai is not there, this is the issue. If it is to be settled. Where is the judgment? Where is that Apex Court judgment in relation to that? There is a judgment of, I think, if I am not mistaken, it's 2019.
2019.
Probably. Yes, Mr. Shulai. This matter is sought to be. They are seeking quashing on the basis of the compromise.
If the matter can be heard on some other day, your lordship.
Yeah, that is what. Madam, there will be a Supreme Court judgment, I think, pursuant to that in 2019. Just check it.
Yes, Ginseng, your lordship.
Ginseng, your lordship, versus State of Punjab and another.
Ginseng is 2012, not that. Why it is 2012 SAW?
Ginseng is 2009, if I'm not.
No. That is the 2019. There is a decision. Anyway, we'll have it on. When do you want it?
Next week also we'll do, Your Lordship. Next week, any day next week.
This. See, we are having a problem with the shortage of one PS, so that is what is the main problem is.
Then
See,
if that be the case, then after a week, Your Lordship.
He'll be back by next
after
week.
a week.
Bishis will be back next week. We'll have it after 2 weeks because
2 weeks, Lordship.
Any
That's fine.
problem
That's
with
fine.
it? No problem.
No problem.
Yes.
Otherwise compromise, only the legal issue.
That is what that hurdle will compose. You want it to be written by the court, or you can take it back. You can place it at the time of hearing. Mr. S. Sen, Learned Counsel, enters appearance on behalf of Mr. Respondent number 2 and 3. The counsel for the parties submit that the matter can be taken up for hearing. Stop. Accordingly, list it after 2 weeks.
Apply.
Hearing item number 11.
Yes.
Your Honor, my senior is coming, Your Honor. Your Honor, my senior is coming, Your Honor. 6.
KP is coming? Yes, it's coming. Please, Your Lordship.
Yes. Yes, Mr. Kika.
We'll just wait for the conducting counsel.
Mr. KP is also coming.
The court will have to wait for this.
No, my lord. Sir can continue.
Achha. My matter is very simple, Your Lordship. May I go again through the synopsis? Whatever is.
Yes, you have to definitely tell the court.
Yes, Your Lordship. Your Lordship, humble petitioner is the headmistress of Archival Higher Secondary School, Tura, since 1993, which she co-founded with one Srimati Viola Sonachi B. Sangma, former chairman, MPSA. Petitioner teaches economics to class 10 students, and on request of the parents of the students of class 1 and 2, conduct special grammar classes to students of classes 1 and 2, first period. A written complaint was filed on 25/4/2019 at about 10 p.m. before the officer in charge, Tura Women Police Station, West Gully Hills District, against the petitioner, to the effect that the petitioner assaulted a class 2 student who is the daughter of respondent number 5 on 24/4/2019. Tura Women PS case number 17/4 of 2019 was registered against the petitioner under section.
What is the FIR?
The FIR is at Annexure 4, page 34, and the type copy is at page 35.
Then matter was investigated. Charge sheet was filed.
Thereafter, the petitioner came to learn. This is at page 2 of the synopsis, Your Lordship. Tura woman case number so and so was registered against the petitioner under section 323 IPC, read with section 75/82 of Juvenile Justice Care and Protection of Children Act 2015. The petitioner came to learn that the said case was registered against her only on 29/4/2019 when the IO summoned the petitioner to the police station. In fact, a social media post was circulated on 25/4/2019 through WhatsApp that the petitioner had assaulted the
All those facts will be relevant for the purpose of...
is relevant, Your Lordship. Before I come to the other. Anyway, I can cut short the entire...
No, there is no need to cut short if something is relevant.
Take it. I come to the next point, Your Lordship. The IO submitted charge sheet number after investigation 75/20 on 28/10/2020. This is to be noted, Your Lordship. The charge sheet was filed on 28/10/2020 and the case was filed and registered on 25/4/2019. These two things is to be noted, Your Lordship. A prayer for discharge was made by the petitioner before the trial court, that is Judicial Magistrate First Class, Tura, and after hearing the parties, learned trial court passed order dated 14/1/2022 directing framing of charge under the opposite section of law. This is Annexure 1, Your Lordship. On revision, learned Session Judge Tura, while holding that Section 82 of Juvenile Justice Act 2015 is not attracted since there is no material to frame charge under the section. However, holding that there is a prima facie case under Section 323, read with Section 75 of the JJ Act 2015. Thereafter, learned trial court, this is the order of the lower appellate court is at Annexure 3. Thereafter, the learned trial court passed order dated 23/5/2023, holding that charge be framed against a petitioner under Section 323 IPC, read with Section 75 and Section 82(1) of the JJ Act, and has posted for framing of charges. It is the stand of the petitioner, here is my case, Your Lordship, that the FIR was registered on 25/4/2019 at about 10 p.m. on the basis of a written complaint. Number 2, the charge sheet number so and so under Section 323 IPC, read with other sections, was filed before the court on 28/10/2020 by the IO police. This is also to be noted, Your Lordship. The most important thing, 28/10/2020.
Charge sheet.
The charge sheet was filed on 28/10/2020.
Yes.
Whereupon the learned trial court took...
FIR was dated?
25/4/2019.
2019.
Okay. And the charge sheet was filed on 28/10/2020.
Yes.
Whereupon the learned trial court took cognizance of the case on 14/1/2022. This is Annexure 1. Clearly revealing on the face of the record that cognizance was taken by the court after clear 2 years and 8 months. Firstly, cognizance of an offence under Section 323 IPC as taken by the learned trial court by order dated 14/1/2022 on the basis of charge sheet dated 28/10/2020 is clearly barred under Section 468 CRPC, and the trial court in GR case number so and so is thus vitiated, being illegal and being without jurisdiction. I stop here for a moment, Your Lordship, and I draw Your Lordship's attention to Section 468 of the CRPC. Hey. 460 speaks about, provides bar to taking cognizance after lapse of the period of limitation, except as otherwise provided elsewhere in this court. No court shall take cognizance of an offence of the category specified in subsection 2 after the expiry of the period of limitation. The period of limitation shall be 6 months if the offence is punishable with fines only. 1 year, where I am more concerned in this particular case, if the offence is punishable with imprisonment for a term not exceeding 1 year. So, by virtue of this particular provision, Your Lordship, the learned lower court could not have ordered framing of charge or taking cognizance after the period of limitation. There is no separate prayer for leave or anything like that. It's not there, Your Lordship. Secondly, I come back to my synopsis, Your Lordship. Secondly, in terms of section 1(4) of the Juvenile Justice Act, Care and Protection of Children Act 2015, the provisions of the said act shall apply to all matters concerning children in need of care and protection and children in conflict with law.
You go a bit slow. I have not got the book also till now. Let the you go a bit slow.
Pardon, Your Lordship?
If you go a bit slow.
Oh, I'm so sorry.
Before I could get the book, you have completed your reading.
My apology.
No, it's all right. JJ Act, what section you are referring?
Section 1(4), subsection 4. Notwithstanding anything contained in any law for the time being in force, the provision of this act shall apply to all matters concerning children in need of care and protection and children in conflict with law. That's all, Your Honor. Further, section 2, subsection 13 and subsection 14 defines the two terms, child in conflict with law and child in need of care and protection, exclusively in elaborate manner. Lordship is having the book. Yes. Subsection 13 provides child in conflict with law means a child who is alleged or found to have committed an offence and who has not completed 18 years of age.
We are not concerned here with this.
You are not concerned. I mean, what I'm trying to say is that GG is not at all applicable. They could not have charge sheeted me under section 75 and section 82.
Yes, no, you just place your point, but then 13 is not coming in any way.
Take care.
Yes. No, you do not have to consider anything. Is it coming? 13.
No. Well, what I'm trying to show you, Lordship, is that the particular victim, alleged victim, because I'm not going into the factual aspect, I'm just going on law. So far the victim is concerned, is not under any protection home or is a child in conflict with law. She's not an offender. She's a student.
Yes, definitely. That is why 13 is not coming. That is what we are saying. It's no way. It is an admitted case.
Admitted case. That's what I'm trying to say, Lordship. Now, subsection 14.
Yes.
Child in need of care and protection means a child who is found without any home or settled place of abode, who is found walking in contravention of the provisions of this act or labor law, etc., who resides with a person, whether so-and-so, has injured, etc., Your Lordship, who is mentally ill or mentally so-and-so, subsection clause 5, who has a parent or guardian and such parent or guardian is found to be unfit or incapacitated. That also is not the case, Your Lordship. What I'm trying to say, Your Lordship, none of these clauses are engaged or involved insofar the child in question is concerned. So what I'm trying to say, Your Lordship, is that none of these definitions and provisions of section 1(4) read with section 2(13) and 14 of the Act of 2015, even in their widest possible interpretation, can include the student, daughter of R5 in question, as mentioned in the FIR, within the periphery of the ambit of section 75 of the Act of 2015, or section 82 of the Act of 2015. Consequently, no trial or offences under section 75 of the Act of 2015 can proceed in instant case based on the FIR so-and-so as well as a charge sheet number so-and-so, Your Lordship. It is the case of the petitioner that no trial or further proceeding in GR case number so-and-so under section 323 IPC read with Section 75 of the JJ Act, can proceed any further under any tenets of law against your humble petitioner accused, as the period of limitation for taking cognizance of the offence under Section 323 has lapsed at the end of 1 year of the registration of the case. Date of FIR, that is 25/4/2019. Also under Section 75 of the JJ Act of 2015, in view of the provisions of Section 1(4) and Section 2(13) and 14 of the said Act, having clearly denoting the contents of the FIR bereft of any ingredients for constituting an offence, even prima facie, under Section 75 of the JJ Act against the humble petitioner accused, that the aforesaid legal affirmatives and basic jurisdictional issues are prima facie borne out of the record of the case and not result of any factual dispute being raised by the petitioner accused, Your Lordship. I'm not going into the other things. The issues are apparent on the face of the record, which deserves primary consideration of Your Lordship before an order in nature of order dated 23/5/2023 could have been passed ordering resumption of the framing of charge against the petitioner accused. For that, in any view of the matter, the entire proceeding under GR number so-and-so, pending before the Court of Judicial Magistrate, Tura, emanating from Tura so-and-so, are liable to be quashed and set aside. This is the short and substance of my case, Your Lordship.
So you want to say that there cannot be a charge under Section 75?
No, Your Lordship, because this is a student. And there are so many judgments, Your Lordship, where it says that a teacher or a teacher in a madrasa, they are exempt, they are protected by Section 88 of the IPC. But I'm not going into that, Your Lordship. I'm going into the fact that JJ Act is not applicable. Let's not go into that Section 88, which is the exception clause. I'm not coming into that. I'm saying at the threshold, I'm not going into the factual dispute. I'm going primarily or directly onto the just jurisdictional issues, Your Lordship. I'm saying that JJ Act is not applicable because this is a student, not a student in any of those falling under clause 14 of Section 2, Your Lordship. I rest my submission. I pray for discharge of the closure of the case, Your Lordship, at this stage itself, because I'm not getting justice before the lower courts, Your Lordship. We tried to impress upon the lower court, but they have ignored this fact, Your Lordship.
What is the impugned order?
That is at Annexure 1, page 18. And the operative part is at page 21, Your Lordship.
What is the section?
Yes, anything more? Lordship, Section 323 provides a punishment of which may extend just to 1 year or fine or with both. And so far the preamble of the Juvenile Justice Act, the introduction part, is very, very clear, Your Lordship. May I read, Your Lordship? Just the introduction part.
Yes, yes. Fine.
The Juvenile Justice Care and Protection of Children Act 2015 contains 112 sections in 10 chapters. It is an act to consolidate and amend the law relating to children alleged and found to be in conflict with law and children. Conflict with law, that means an offender, Your Lordship, child offender. And children in need of care and protection.
You are reading which part of the...
Introduction. Just the introduction of the Juvenile Justice Act, Your Lordship.
Of 2015 Act. You are reading the introduction part of 2015 Act.
Yes, yes, Lordship.
Yes.
The GJ Act of 2015 contains 112 sections in 10 chapters.
Is it the starting line?
This is a starting line. The Juvenile Justice. The introduction.
It is something different here. 2015 Act.
Can I share, Your Lordship? Introduction, some sort of a preamble.
Just compare these two books. The down one is yours.
Yes, Your Lordship. Let me go to the main preamble, Your Lordship. Perhaps that's just some sort of a commentary. Let me go to the main preamble, Your Lordship. 31st December 2015. An act to consolidate and amend the law relating to children alleged and found to be in conflict with law and children in need of care and protection by catering to their basic needs through proper care, protection, development, treatment, social reintegration, by adopting a child-friendly approach in the adjudication and disposal of matters in the best interest of children, and for their rehabilitation through processes provided, and institution and bodies established herein under and for matters connected therewith or incidentally dealt with. Your Lordship, what I'm trying to say here, Your Lordship, that so far the student concerned, the mother of the student was originally a teacher in my school, Your Lordship. She left and joined a government school. I've given that in my petition, Your Lordship. And I had the animosity was from the father's side. We'll not go into that. That's why I didn't want to go to factual dispute.
No, definitely, this court will not be in a position to determine all those things, even if you raise it.
My
at this stage,
my case here is basically straight on the provision of law. What does the law say, Your Lordship? So far, Section 322, the maximum punishment is 1 year or fine or with both. And Section 468 of the CRPC provide, subsection 2, clause 2, says that it should be, cognizance should be 1 year.
No,
that the charge sheet was filed beyond 1 year, Your Lordship.
But that is okay. But then if, say, supposing, if you can prove that Section 75 Juvenile Justice Act will not lie, in such a case your first contention will stand. Otherwise your first contention will not stand.
That's what I'm trying to say, Your Lordship. I have
your contention that 323 is barred by limitation will stand only if you are successful.
According to me, Your Lordship,
yes,
the main charging section is 323. In charging section.
That may be your understanding, but then I don't think.
Section 1, subsection 4.
Yes.
May I read again, Your Lordship?
Yes.
Notwithstanding anything contained in any law for the time being in force, the provision of this act shall apply to all matters concerning children in need of care and protection and children in conflict with law. So simple, Your Lordship. It's in conflict with law, in need of care and protection. The child must be without parents, etc., etc. Must be in a home run by institution under the JJ Act. Now, Section 2, subsection 13.
You have pointed out.
Yes, Your Lordship. That's what I'm trying to say. That the JJ Act, by whatever reading, is not applicable so far this case is concerned. The student, the complainant, is the mother of that child in question. They are not residing, she is not residing in a home, the child in question. And neither the child is without parents. And the institution is a school, Your Lordship. A private school, not a...
Let us come to Section 75. Let us read Section 75.
Yes, punishment for cruelty to child. If you are going to read Section 75, Your Lordship, you have to read also in conjunction the definition, as I have mentioned earlier, Your Lordship. Whoever having the actual charge of or control over a child assaults, abandons, abuses, exposes, or willfully neglects the child, or causes or procures a child to be assaulted, abandoned, abused, exposed, or neglect in a manner likely to cause such a child unnecessary mental or physical suffering, shall be punishable with imprisonment for a term which may extend to 3 years, or with fine of 1 lakh rupees, or with both.
So here punishment is 3 years.
Yes, Your Lordship.
So if we take together both the offences, that limitation will not stand. That is so far as the... See, but the only thing is that, like if you are successful in, you see, showing the court, what you have shown already, in fact, that Section 75 will JJ Act will not come here, then definitely you have a case.
I have been able to impress upon this court and show that this child in question does not fall under the category of the definition under Section Clause 14 or Clause 13 and 14 of Section 2, the definition clauses.
That is so far as the Act is concerned.
Yes, Your Lordship. JJ Act is not for any other child.
We'll just hear the other side. Let us see what they say. There may be some decision by which that definition stands expanded.
If they can show,
yes,
it will be very good. I have got a lot of citations insofar of corporal punishment of students, etc., etc. They come within the exceptions of Section 88 and 89. So, but here it is not applicable. I'm not coming into factual aspect. So I'm not.
No, this section 1(4). Does it limit the application of this act?
Yes, Your Lordship. By conjoint reading with section 2, subsection 13 and subsection 14. It cannot be read in isolation. It cannot be read in isolation, Your Lordship.
Now it starts with notwithstanding anything contained in any other law for the time being in force. The provision of this shall apply to all matters concerning children in need of care and protection and children in conflict with law.
Agreed. Agreed. Now, what is the definition of children in need of care and protection? That is subsection 14.
You have already gone to that.
What's the definition of children in conflict with law? That is subsection 13.
Now, that is what the question of the court is, that whether the application of this act would only can be confined to these two categories of children. Two categories means children in need of care and protection and children in conflict with law. These are two categories. Or it can be stressed beyond. Supposing that's for a general query, may not be applicable to a specific case. What happened to the students, the normal students, your kid, my kid, who goes to school, remain there? And if they, supposing, face some sort of torture by teachers there,
yes,
that will not come under the Judge Act.
No, it will be under the regular.
Yes,
law.
Let us see what the state says. Just address the court on that issue. Nothing else is needed, Mr.
My Lord, if I may kindly take my Lord to the Act itself, my Lord.
Yes.
My Lord, the Act is very clear. It says Juvenile Justice, Care and Protection of Children, Act 2015, my Lord. So, my Lord, it is also meant for the care and protection of the children.
That is what? That is precisely the question of the court.
Yes.
Now, whether, see, the learned senior counsel here has pointed out to that clause, subsection 1, subclause 4.
My Lord.
And his submission is that, you see, this act will apply to those two categories of children. Now, your submission is something beyond that. Now, if you want to say that, then you have to show some certain
every
law.
child. My Lord, every child is entitled to care and protection, my Lord.
This is normally you are saying.
Yes, my Lord.
This is general perception you are saying.
My Lord will kindly see what is the definition of child, my Lord, as per the juvenile justice.
Now, what happens? Say, supposing if a child
yes, my Lord,
is abused or
yes,
tortured by parent,
yes,
can a parent be charged under Judge Act?
My Lord, if there is gross abuse, then yes, definitely.
On what basis you say? The abuse is abuse. What is gross abuse and all? The normal question is that, say for this kind of complaint which has been made in this case.
In fact, my Lord,
if that complaint is made on behalf of a kid,
yes,
against the parent,
yes,
then what happens?
My Lord, the act will take its course, my Lord. My Lord, the parent is liable for punishment, my Lord. And there are cases, my Lord, where my Lord, there are certain cases, my Lord, where a child is. My Lord,
now, whether parent will be whether parent will come to 214. You see, do not just argue on the general perception.
My Lord,
what this could do, if you require further these things, okay, so there is no problem.
My Lord.
But then if you say something, you have to substantiate it by law.
Lord, as far as judgments are concerned, of course, I don't have it today, my Lord. But this honorable court, while my Lord delivering its judgment, my Lord, it said it
now come to 14.3.
My Lord.
214.3.
214, my Lord.
Section 2, subsection 14, and then Roman 3.
Who resides, my Lord, child in need of care and protection means child. And 3, my Lord, who resides with a person, whether a guardian of the child or not. So, my Lord, whether the person is a guardian or not.
That is what the thing. See, you have to elaborate there. If you want to bring the petitioner under the clutches of that law,
my Lord,
now that is what. You see, it is not that if you are to give a broader interpretation to those petitions.
And of course,
These definitions.
I will require, my lord.
Definitely
some
will
judgments will be
require,
required,
but
my
then
lord.
this is something is a query. I do not know, because whatever this court decides will have a.
What is in the same, my lord, in the same definition? The definition of child is also given, my lord. What it says? Child means, my lord, it does not say child in special care and all that, my lord. Child means a person who has not completed 18 years of age.
That is okay. Then what about subsection 1(4)? Come to subsection 1 and subsection 4.
Subsection 1. Notwithstanding anything contained in any other law for the time being in force, the provisions of this act shall apply to all matters, my lord.
Yes. Read it.
All matters concerning children in need of care and protection and children in conflict of law.
So, see, this act broadly categorizes children into two
categories. Yes, my lord.
Now, if you go by your definition and if it includes three, then there has to be 3 categorization. One is children in need of care, one children in conflict with law, and one is normal children. If we have to confine, see, now the child in need of care, section 214. Now that is what vital is.
Apprehension, it says, my lord, apprehension, detention, prosecution, penalty or imprisonment, rehabilitation and social reintegration of children. So this is as far as the conflict is concerned, my lord.
Yes. And then 2 procedures and decisions, or orders relating to rehabilitation, adoption, reintegration and restoration of children in need of care and protection.
Lord, I understand what has fallen from my lord.
So this is the application thing. You have to concentrate more on that. You have
Lord,
to.
I will require the help of certain judgments, my lord.
Definitely, you will have to.
Research will be required, my lord, in this. What? But the honorable court, my lord, while rejecting the.
Now, if you say subclause 3, who resides with a person,
my lord.
Now, would it mean a permanent resident or if it's a temporary thing? I put my child under the custody of my neighbor for 2 hours.
Yes, exactly, my lord.
I come back. I'm just
no, there is
giving you those thoughts.
There is a similar situation.
No, there has to be certain.
There is a similar situation. There are parents who go for work. They leave their children to crutches and all those places, my lord. So there also the child is supposed to be taken care of, my lord. Now, what will happen if certain incident, some incident takes place there, my lord? The primary intention of the law is to, my lord, protect the child, my lord. It's for the protection of the child.
Yes, Mr. Kinta, we will be needing further deliberation on that part. You have finished your part.
My lord, I'll look for some judgments, my lord. But however, the honorable court, my lord, while rejecting the case of the petitioner, my lord, has referred to, my lord, 2 judgments. State of MP.
One part, this child in need of care.
Yes, my lord.
Has to be when we read
now. Say
14,
supposing
when we read 14, your lordship, we have to read at class 1. Who's found without any home or settled place of abode and without any ostensible means of or etc.
That is subclause 1.
There are 3 classes.
There are
now when we talk about institution or home means those institution under JJ.
See the care and protection, and that is one thing. You see, that is.
I agree with the contention of the government council that if there is some precedence in support of his case, we can come back, your lordship.
See, there has to be. You see, like honestly, this court, because you see, if any order is passed, it will have a.
My job is to assist the court, your lordship, not only to help my client.
I understand. I appreciate that.
I'm not here only to win a case.
No, you have
because
you have raised very pertinent
this
issues.
Is a very important case, your lordship, and it will be a precedent set all over the country. And I agree that.
Is there any instance of teacher charged under JJ Act?
No,
Before-
that we'll have to find out.
No, just take into consideration. This is, but then apart from even that may have happened. Maybe earlier nobody had took the stand which senior counsel taking now. But then this is one point you have to conduct
into
some research.
I'll do some research. I'll do some research in this regard. Well, because otherwise also there are several cases.
There are several High Court cases on this matter, Your Lordship, and because they are relating to Section 323, but there are some under Section 75 where the High Court says not applicable. If this is extended, Your Lordship, the hearing, they will come. We'll try to assist the court, Your Lordship. That's my.
That is what. And if there is any such decision which, say, supposing this kind of issues came before any other High Court, and then there exists some decision which says that the school teachers cannot be charged under JJ Act.
There's a
Person
case
can
of a maid
only
servant,
charge
Your
under
Lordship.
normal laws.
There's a case of a maid servant. She was charged under 323, including JJ Act, and the court quashed everything because he went into factual dispute.
You have a decision of that
On the next date, Your Lordship.
by a High Court.
All those decisions were High Court, Madras High Court, Kolkata High Court, Bombay High Court.
But then if you have that decision, that will be supporting your case then.
The issue here, Your Lordship, I'm not going to factual thing. No? I'm the principal.
But then
I
say
happen to be the
supposing,
principal.
say
Teaching only
supposing,
class 10. Accidentally, I went to class 1 or class 2, that is morning section. And there was no report of anything that I have done. Only after more than 36 hours, this thing came up.
No, but in the fact remains there exists one FIR
Yes.
and the charge sheet, and
don't
you can
want to-
understand
My lord,
the limits of jurisdiction at this stage.
Your Lordship, the
Under 482.
respondent number 5, we did not avoid making party. Intentionally, we have made it party. In case they want to come and say something, that
They've been made a party.
they've been made party. I have not.
Notice was issued to them.
Notice was issued.
They have.
They, in fact, instead went to our local lawyers, say, "Arey, why this case is pending? They should have come here and tell this court, Your Lordship." But they
But
did
then
not.
even in spite of that, the question of law will remain.
I'm here on law, Your Lordship. What does the law says? I'm not going into the nitty-gritty, Your Lordship. I'm the principal, not only principal, Your Lordship, I'm a high profile. I've been accredited by the government of Meghalaya. My husband is in a high position, Your Lordship. My reputation is at stake here. The trial proceeds, Your Lordship. I'm not just an ordinary person. I started a school to help the people of Garo Hills, not to earn a profit or benefit, Lordship. We are not getting government grants and all these things. We have been teaching English very well, Your Lordship. Grammar especially.
my lord, with due respect, my lord, but law should be equal for all. My lord.
No, that is definitely.
Yeah, that's why we have come before
There's
this.
no dispute with regard to that.
Will require some research, my lord. As far
Yes,
as
please
the-
make the research. Do not make the court to make the research.
No, my lord, I'll do
It
from my
becomes
side.
quite.
Even the definition of child, my lord, is very clear.
Definition of child, definition of juvenile, everything is clear.
My lord.
But then the problem remains. That is what we say.
Whether it extend beyond.
See, the application of the Act, apart from these two categories. Now, the simple contention here is that the child, when a child is in school, the child can neither be categorized, child can neither be categorized as child in care and protection, nor, and so far as the fact is concerned, is not a child who is in conflict with law.
No, he is definitely,
So
the child is definitely not
the
incompetent.
simple condition is that this act applies to only those two categories.
My lord,
Now, one thing is that in general, what happens? Say, like, can we carve out some third category of child? That is what the main thing.
my respectful submission is that protection of child, my lord, even the schools will come.
That is, you are
Because
making
I
a
am-
submission.
let's assume
It's
a
all right.
situation, my lord.
If you make a submission, you have to give some supporting role. But in school is not been defined. 221C, 221. School doesn't come under 221. 221, is it? Yeah. Section 221. See, child care institutions.
Yeah.
Means children home, open shelter, observation home, special home, place of safety, specialized adoption agency, and a fit facility recognized under this act for providing care and protection of children. Now, where is that? School doesn't come under here.
Child care institution.
That is what?
My lord, it speaks of adoption.
Yeah.
Shelter, observation home, special home, place of safety, specialized adoption agency.
This is a very interesting issue. You should.
My lord. My lord, another question which also I would ask myself, my lord. Now, if there is, my lord, any violation of any of the rights or harassment of a child besides the POCSO, my lord, what would be the other provision?
IPC is there. Indian
IPC
Penal
is
Code
there,
is
no
there.
doubt, my lord.
Even when POCSO was not there, IPC was there.
That is there, no doubt.
These are special acts. Okay, this came. It was not that even this juvenile was. You see, there are some law to take care of this also. But then, after this Juvenile Justice Care and Protection Act came, that has been taken special care. These are all special acts.
I'll look for some judgments, my lord, if it helps the case.
Because if you treat this matter under the normal law, then it is barred by limitation. 462 will be barred. 468.
That is one section, my lord. Now,
That is
whether-
what?
That section merely explains, my lord, only causing some voluntary injury, my lord.
Simple injury.
Simple injury.
No, but then the fact remains charged under 323. You cannot go beyond that. Your investigating agency is charged under 323. So, what is the question of stretching any argument beyond that? We'll give him time.
But
Yes, yes, Your Lordship. Because this will be, I'm more interested that whatever flows from this court, Your Lordship, will be a precedent.
That is what.
That will
That
be
is
a
what.
precedent.
That is what. This court must be very much careful.
Clear-cut precedent we are looking at, Your Lordship. Will not take this lightly, Your Lordship. Will come and assist the court on the next date.
You have to be in this kind of things, you see. You cannot take things lightly, you see, you cannot. These are serious issues. Maybe a small case, but then the issue is very serious. The question involved will have a far-reaching consequence.
Whether GG Act will be applicable insofar as students or children of so and so at their home.
Because nowadays
Whether
you
that
hear
GG
about
Act can
many.
be extended to mother, father beating the children.
That is what.
Oh, very. And
but, as far as Western countries, my lord, that is very much there. You'll be immediately booked.
I made a
Shall
lecture.
be sent for foster care.
There must be a law, set of law for that.
My lord. They are very strict about that, my
Okay,
lord.
so
Even
you
a
have
phone
to,
call.
but then here you do not say anything. Okay, you have taken care of maybe the father and mother by virtue of that subclause 3 of section 14 who resides with a person. Now, if you place a child in a school, can you say that the child was residing temporarily there? Now, that is what. Now, if you can bring it under that, then definitely the petitioner will have no case.
I was weekly watching that program held by High Court on Juvenile Justice Act, where Your Lordship also was present on the day. It was a very. I was watching the entire.
I just remain present because I have to be there. That's why.
Lordship must be well acquainted with this matter.
No, I'm not well acquainted. Only
But-
thing is that
but
whenever
there
a
was-
matter comes, I just try to apply my thought into it. That is what I try to do it.
I was watching that. I had given several lectures on this subject, Your Lordship. Now that we are not on a case anymore, on the same matter, Your Lordship, because being a member of District Legal Services Authority, I go all over the areas and villages and my that time, that was 2-3 years back. My case is that who are the children in conflict with law? Who are the children in need of care and protection? Not all children. Because this query was coming from the villagers. What the court was asking just now was coming from the villagers. Kikhon Jangi, what happened Kikhon Jangi? Are sure. But there's other laws. I'm not here to spell it out but there are other laws how to go about. But in so far this case is concerned, I say that the main charging session is 3 to 3, not beyond that. Lordship will take leave. Will come again.
If it is found that if not under Section 75 JJ Act, the accused can be charged under some other law, then what would happen?
The trial court could look into that.
My lord,
The trial court did not. This court will not go into that.
Trial court has the power to alter charges also, my lord.
Trial court could have done it, but twice it has passed orders on the same beyond anything, Your Lordship. This court will look into that, whether 323 is barred by limitation to take cognizance, whether JJ Act is applicable to a student. That's all, the limited issue before this Honorable Court, Your Lordship. We'll come with precedents. I was under impression that state will bring some precedents today, Your Lordship.
Anyway, heard Mr. VGK Genta, learned senior counsel, assisted by Mr. Wan Song. For the petitioner, also Mr. Kapi Bhattacharya, learned GA for the respondent. Mr. Bhattacharya submits that since an important question of law has been raised with regard to the applicability of Section 75 of the Juvenile Justice within bracket care and protection of children close bracket Act 2015. Just read the thing. Just read the sentence. I guess. For the petitioner. Since you do one thing. अच्छा which got a second survey होता है JJ Act in the present matter, comma he requires some further time to prepare. Stop. The learned senior counsel for the petitioner has no objection. When?
My lord, I'll prepare 3 weeks on it so that I don't take time again.
3 weeks? You do not need 3 weeks. If you do it carefully, 3 days will be enough. Anyway, we'll give you 2 weeks.
My lord.
Yes, Mr. Kinta. Mrs. So-and-so. Prayer allowed, list after 2 weeks. Mr. Kinta has no objection. Then thereafter you write prayer. What's that say? Lord? Prayer of the rest. Prayer of the yes, prayer Lord. List after 2 weeks. When I come to the end of the line and forget the starting of the it's good.
Lordship, actually, I
So
was-
you have given a new dimension to the thought. That is good. But then even this court also will have some question in its mind with regard to the normal situation. Say supposing if your submission is accepted and it is held to be correct, then in schools or any other institutions where kid goes, be it a dance school or singing school, whatever it is, and if the kid faces some sort of physical assault and all, the offender cannot be charged under JJ Act. They will be kept out of the purview of JJ Act.
Yes, yes. That's
Then
yes.
the very purpose for framing that special act would be defeated to some extent.
That law was made for some. That's why that time I wanted to read the introduction, but it is different from your Lordship's book.
No, yours one is some commentary,
It's a comment.
and this is it.
What was the
So,
introduction?
so that is what things. Anyway, it's nice to.
I can't. Lordship will, next it will come back.
1 minute. Probably I'll just keep these notes.
Today I'm supposed to travel, Your Lordship. I physically avoided. I thought I'll travel.
No, it is good at least. We.
Because I wanted
This is good to hear this kind of matter when the court also has not much matter before it, so we can concentrate. Please.
Rajwan.